Hello and welcome to our webinar this afternoon. I'm Joanna Goddard at BWV. I'm a senior associate and I'm joined today by my colleague Rosie Brown, who's a solicitor. We will have worked with many of you before on actual cases. So this is the first time we've done an equality update webinar, and it's good to see so many of you attending. What we plan to do today is to go through the protected characteristics in the Act. And then we will be going through the most common forms of prohibited misconduct under the Act, which is direct discrimination, indirect discrimination, discrimination arising from disability, and the duty to make reasonable adjustments, as well as touching on harassment and victimisation. And then we will go through the education-specific provisions with some practical application, mainly in the form of sanctions and exclusions of disabled pupils, because that's where we usually as I was saying, then we'll have some practical application, mainly in the form of sanctioning pupils who are disabled. We did intend, when we first sent out the invitations, to then touch upon the thorny issue of gender reassignment. That was because when we put this in as a late webinar in November, we were expecting the DfE to have published its long-awaited and promised gender reassignment guidance by now, because they said we'd have it in the autumn, and we're arguably verging on winter now. But we do feel that it is imminent, and we don't feel that we'd be able to address it in a meaningful way today without having the actual guidance that we've been promised. So what we will do in relation to gender reassignment is, as soon as we get that guidance, we will of course analyse it, and we will do a stop press academies and schools law brief, which is our easy. Most of you will be signed up to it because that's usually how you get the invitations to these events. But it comes out termly, sometimes bi-termly. It's free. It has 5 or 6 articles written by specialist lawyers across the firms who work solely with academies and maintain schools. And you can sign up to it on our website if you're not already signed up to it. You can unsubscribe anytime. We will do a stop press, i.e. a special edition of that, when the gender reassignment guidance is finally published. And then we may well do another free, shorter webinar focusing entirely on that. It really does depend on what it says when it comes out. But we think that would be far less confusing than going through what we think is the situation now, which could be obviously turned on its face as soon as the new guidance comes out. Just to answer the question that's just been asked, this session is being recorded, and in a week's time or so, once it's been edited, etc., it will be sent with the slides and with a crib sheet of the law to all of you, including those of you that can't attend or have to leave early, or anything like that. So everybody that registered will receive one. Next slide, please. So this is just a slide that sets out some useful guidance. Now, at the top of the list, we've obviously put the DfE's guidance, which is very old now. It's getting on for a decade old, the Equality Act in schools. We don't find this guidance very helpful at all. It's long overdue for being overhauled. What we tend to do is go to the Equality and Human Rights Commission, who are the regulator for equality law matters and human rights matters, because they publish a great deal of what they call technical guidance with lots and lots of practical application, and they do it not just generally but for certain sectors. So what I've done is, these are actually hyperlinks, so when you get these slides you'll be able to click on these, and they are in the crib sheet as well. So the second one down is not specific to schools and academies, but it is specific to people who services for public functions and associations. So basically, schools are education establishments for the purposes of the Equality Act, but they are also service providers. And we find that this particular document contains far more helpful guidance about the actual prohibited conduct than the technical guidance for schools, which is the third one down. The technical guidance for schools is great because it applies what's in the second guidance to a school situation, and it really helps schools with meeting their duties. Then there's specific guidance, the fourth one down, on making reasonable adjustments for disabled pupils. So this is quite a lengthy document that's dedicated solely to making reasonable adjustments for disabled pupils in a school. And then there's a general guidance document for all those that are subject to the public sector equality duty. And on that note, this webinar, we've obviously got a very large client base of schools, some of whom are independent schools and some of whom are academies and maintained schools. We have prepared this webinar for the target audience of academies and maintained schools. So if any of you actually work for an independent school, you might still be on this session because you're a governor of a state-funded school. You know, there might be a variety of reasons why you might want to come on this, but just bear in mind that when we're talking about the public sector equality duty, it doesn't necessarily apply to all independent schools. It might apply to some, depending on their status and how they're set up. I don't actually work on a day-to-day basis with independent schools. Next slide, please. So I'm going to hand you over to my colleague Rosie, who's just going to take you quickly through the protected characteristics.
Well, good afternoon, everyone. So we've set out on this slide a reminder of what are the characteristics that are protected, and we're going to refer to them throughout this webinar as protected characteristics, or PCs for short, that are those that are protected under the Equality Act. And so I'm not going to read out this list for you, but you will see that against the characteristics of age and marriage and civil partnership, there are asterisks, and that's because these two protected characteristics do not apply to pupils in a school, but they're included on this list because they will apply to everyone else. So that may be your staff body, your parents, and anyone else. So we would like you to bear these in mind as we go through this session. So if we have the next slide, please. So bearing those protected characteristics in mind, we're now going to come on to look at the prohibited conduct under the Equality Act. And the first one that we're looking at is direct discrimination. So what is direct discrimination under the Equality Act? Well, this is where a pupil is treated less favourably than another because of their protected characteristic. Now, importantly, the definition also includes their perceived protected characteristic, and it can even include the protected characteristic or the perceived protected characteristic of someone that they are associated with. Now, to be successful in demonstrating direct discrimination, you do need to have an actual or hypothetical comparator to be able to show that another pupil without that protected characteristic has or would have been treated better or more favourably than the people with the protected characteristic. Now, it is important here to note that with direct discrimination, there is no justification for this or defence, and that is regardless of however good the intention of the school or staff member may have been. So we would like you to bear this definition in mind for the next slide, please, Emma. As we have the first of our questions for you. Now, these are just some quick fire poll questions. And what we would like you to do is to select all of those that you think are examples of direct discrimination. And we'll just give you a minute or so to do that. Okay, lovely. Well, I will just very quickly take you through the answers. So The first question we had was the shop that has a sign on the door that says no travellers. Well, absolutely, this is direct discrimination, and that will be on the protected characteristic of race. Likewise, with our job advert that says that male candidates are sought for the role of school handyman, again, that is direct discrimination, again, on the basis of sex. So our third scenario here is that attention is given to a pupil with ADHD for fidgeting in class and disrupting other pupils. Well, we are going to touch on, address this in much further detail later on, but this is unlikely to be direct discrimination and much more likely to either be indirect discrimination. It might be discrimination arising out of disability, and it could also be a failure to make reasonable adjustments. And these are all elements that Jo will be taking us through in much further detail later on. So our next scenario is that all female pupils in a drama class are invited on a theatre trip to see Mamma Mia. Well, there's a slight caveat with this one. So if you are a mixed sex school, then it is likely that this is direct discrimination. And finally, we have our last scenario where a boy is not allowed to join the school's after-school club run by a Christian coach because his parents are gay. So in this scenario, this is going to be direct discrimination. And it's going to be because of his association with his parents. And his parents are the ones who have the protected characteristic of sexual orientation. So now we've had a quick look at that, I'm going to hand you back over to Jo, who's going to take you through the next of our prohibited conduct.
Thank you. So I'm just going to go through in indirect discrimination for you. This is far more likely in a school environment. Indirect discrimination is under section 19 of the Equality Act 2010. The reason why we're giving you the section numbers is because in a tribunal situation, often the judges talk in terms of the section number rather than in terms of the description of the prohibited conduct. What happens with indirect discrimination, and you'll see as I'm going through it that there's a very close relationship between indirect discrimination and the duty to make reasonable adjustments for disabled pupils. The school has a neutral policy criterion or practice, and we've shortened that to PCP for the purpose of these slides, and obviously across the sector in not just education law, regulatory compliance, but also employment law, the term PCP is widely used for a policy criterion or practice. So the school has a neutral or supposedly neutral policy criterion or practice, and it applies it generally to everyone without regard to protected characteristics, but the PCP puts or would put pupils sharing a protected characteristic, including the pupils seeking to rely on it, at a particular disadvantage compared to those without it. So you can see I've highlighted the term particular disadvantage. That's because the duty to make reasonable adjustments for disabled pupils requires a substantial disadvantage. This requires a particular disadvantage, but it's similar to the first limb of the two limbs of the duty to make reasonable adjustments that schools have to make. So breaking this down, the school has to have a policy, a criterion or practice. It doesn't have to be, you'll see at the bottom, it doesn't have to be a formal policy. It doesn't have to be written, published. You don't have to have met and discussed it and decided that you're going to have this policy. It might be something that you've just been doing for years and everybody knows that that's what happens. For example, the policy of girls using girls' toilets. Schools don't usually have a written policy that says only female pupils can use the female toilets, but everybody just knows it's this unspoken rule. And if it's this unspoken rule, it is a PCP. It's a practice. It's criteria. It's a prerequisite. It's a rule. It's an unspoken policy. So that's what a PCP is. What the person was seeking to rely on it has to demonstrate is the policy criterion or practice would put pupils sharing a particular protected characteristic, and don't forget that this applies to all protected characteristics, or at least in relation to pupils, all relevant protected characteristics, so not age and marriage and civil partnership, not just disability. So this is where it gets more interesting in terms of it having wider application. They have to show that it puts pupils sharing that protected characteristic at a disadvantage, but they also have to show that it puts them at a disadvantage. If they can show it would put pupils sharing the protected characteristic at a disadvantage, but they themselves weren't actually put at a disadvantage, then they wouldn't be able to rely on this. And it doesn't matter that the consequence was unintended. It doesn't matter that the school hadn't thought about whether or not it would put them at a particular disadvantage. Now, the school can defend applying the PCP to everybody without adjusting it for those at a particular disadvantage because of their protected characteristic, if they can demonstrate it's a proportionate means of achieving a legitimate aim. And you'll hear this again because it does apply to other aspects of the Act. It's known as objective justification. That's what the Equality and Human Rights Commission tends to refer to it as in its technical guidance, but in the Act it's called a proportionate means of achieving legitimate aim. Next slide, please. So in terms of disadvantage, so you have to show it's a particular disadvantage. The Act doesn't actually define what disadvantage means, but the technical guidance does give some help. So it describes it as a denial of opportunity or choice, deterrence from actually doing something. So if the policy puts them at a disadvantage in a way that it deters them from taking a course of action because of their protected characteristic, or a rejection, an exclusion, or a detriment. So it's the literal sense of the word in terms of disadvantage. So it can be anything really. If the person feels that they have been disadvantaged, that would probably be enough, as long as there was some material disadvantage. But they don't have to actually quantify it, and they don't have to demonstrate they've actually suffered an actual loss. It's sufficient for them to just demonstrate that they have been put at a particular disadvantage. They have been, some detriment's been caused to them. And then objective justification. So this is the proportionate means of achieving the legitimate aim. Now, this is the most important aspect of this. This is where we find we spend most of our time working out whether or not applying a policy generally to all pupils in this case. And if we think about it logically, the most common policy we're talking about, the most common PCP we're talking about is the behaviour policy. So if you think about applying your behaviour policy equally, exactly the same to all pupils, obviously there are categories of pupils who would be at a particular disadvantage by the application of your behaviour policy. And the obvious one that springs to mind are disabled pupils who have behavioural disorders. So what you're looking for, if you have applied your behaviour policy to them without adjusting it or without adjusting it enough, if that's what the parents are alleging, is the aim of applying it to them legitimate? And by that, the guidance says, is it legal? Is it non-discriminatory? Is it one that represents a real objective consideration? So it just needs to be something tangible. There needs to be a proper aim, a legitimate aim for having this policy and for applying it to everybody without exception. And some of the reasons that they give for being able to demonstrate that it's a legitimate aim is, if you have the policy for health and safety reasons, or for order and discipline reasons, or for the prevention of fraud or abuse, you should be able to demonstrate that you have a legitimate aim. Now, in the case of behaviour policies, this is not a hurdle that it's hard to jump, because you will almost always be able to demonstrate that the purpose of imposing sanctions, applying your behaviour policy to pupils, is to keep order and discipline. And that has been accepted by the tribunals to be a legitimate aim. So the question then comes down to, the aim is legitimate, is the means of achieving it proportionate? And what the guidance says about that is it appropriate and necessary in all the circumstances of that particular case for you to apply the PCP across everybody without adjusting it for those at a particular disadvantage? So you've accepted they are at a particular disadvantage, but is it proportionate? Is it appropriate and necessary for you to have applied it to these these pupils with this particular protected characteristic. And what they will look at with deciding whether or not it is proportionate is, was there another reasonable way of achieving it? If there was a different way of achieving order and discipline, for example, then you won't be able to demonstrate that not adjusting your policy in these circumstances is proportionate. And crucially, it isn't a defence to be able to demonstrate that you didn't intend to cause disadvantage to these pupils with a protected characteristic. So even if it's an unintended and even unforeseen consequence of the policy, then you won't be able to demonstrate that, you won't be able to use that as a defence by saying, well, we didn't mean it, there was no intent, it wasn't deliberate. I recall many years ago acting for a school who had admission arrangements, and obviously admission arrangements, they're a PCP, so therefore they're capable of being indirectly discriminative. They're also, when we get onto it, a PCP that will need a reasonable adjustment, or an adjustment where it's reasonable to make one. But this school had admission arrangements that gave priority to pupils that attended a particular church of a particular designation of religion, and they were accidentally, and the school hadn't even thought about this, they caused disadvantage to the strong Polish community in that area. The religion was Catholic, and the Polish community in that area, there was quite a lot of Polish people, and they had their own Polish Catholic church that they preferred to attend. So if you can imagine, in those circumstances, they were at a particular disadvantage because of their race and the fact that they had their own particular church that had been there for decades, that they liked to attend in their own language, meeting people of their own nationality, etc. They were at a disadvantage under the PCP, the admission arrangements of the school, because their children didn't get priority because of that. So that was an example of where admission arrangements could be indirectly discriminative. Next slide, please. So here we have our second question, which is another poll. I think we only need probably about 30 seconds on these polls because they're not very long. So what we're saying is, please can you indicate which of these, and it's not one, it's choose all that apply, you think could be indirect discrimination. I mean, obviously we can't say for sure they are, but who do you think, which of these do you think could amount to indirect discrimination? So we have only permitting pupils assigned the male sex at birth to use male toilets, refusing to allow people with ASD to go on a school trip because they may have a meltdown, permanently excluding all pupils found in possession of drugs using a zero tolerance approach, applying minimum academic entry criteria for year 12 to all candidates without exception. So this is quite interesting. So we've got some variation here. So going through them, so we have only permitting pupils assigned the male sex at birth to use male toilets. Well, this is a policy, criterion, or practice. It doesn't matter if it's written down or not, but you have a policy of only letting pupils assigned male sex at birth to use the male toilets. Now, setting aside the issues regarding gender reassignment, not thinking about that at all, it is still a policy criterion or practice that is putting pupils with the protected characteristic of sex, i.e. females, and potentially gender reassignment at a disadvantage. So it is capable of being indirect discrimination. I'm not saying it definitely will be, but it's capable of being indirect discrimination because it is a PCP. So refusing to allow people with ASD to go on a school trip because they might have a meltdown. So a lot of people went for this, and I can see why. It was a bit of a red herring, but there is no PCP here. So the school doesn't have an unwritten policy applied to everybody that says we're never going to allow children with ASD to go on school trips because they might have a meltdown. This is a decision that's potentially made in relation to a pupil that has ASD, rather than the school having a policy of never allowing ASD pupils to go on school trips. I mean, frankly, if they did have a policy that said pupils with ASD can't go on school trips, that would be direct discrimination as opposed to, as well as indirect discrimination. What that will amount to, though, is potentially discrimination arising from disability, which we're going to go through in the next slide, because the potential to have a meltdown is something that arises from the ASD, and the decision has been made as a result of that. And it could also be a breach of the duty to make reasonable adjustments, which we'll get onto a little bit later as well. Permanently excluding all pupils found in possession of drugs, sorry, it's cutting off what I can see, so I'll have to go back to the slide, using a zero tolerance approach. Now, not many people went for this, but obviously a zero tolerance policy is a policy, so it is therefore a policy criterion or practice. So it's potentially capable of being indirect discrimination, but of course you do need to demonstrate that there is discrimination as well. So you need to demonstrate that there are pupils who are at a particular disadvantage because of your zero tolerance policy. Now, it gets a little bit harder to get there, but actually some pupils with behavioural disorders have symptoms like impulsivity, failure to recognise the seriousness of their actions, being easily led, that sort of thing. So I'm not saying it would always be the case in all circumstances if you had a zero tolerance policy, but it is a PCP, and there are certain categories of pupils who could be at a particular disadvantage by any policy under your behaviour policy that has a zero tolerance approach. And obviously, separately, this is not a webinar on behaviour or exclusions or sanctions, but actually zero tolerance policy should be avoided because there are lots and lots of things you have to consider on a case-by-case basis, which zero tolerance policies encourages you not to do. And then applying minimum academic entry criteria for year 12 candidates without exception. Again, minimum academic entry criteria is part of your admission arrangements. It is a PCP because it's a policy. It's criteria in your admission arrangements, which is your admission policy. If you apply them to all candidates for year 12 without exception, that's capable of being indirect discrimination because there could be candidates that are put at particular disadvantage by that. So, for example, if you've got candidates who didn't achieve the minimum academic entry criteria because of a disability, for example, cancer, which is an automatic disability, then failing to adjust your policy to address that particular disadvantage could be indirect discrimination if you can't justify it as a proportionate means of achieving a legitimate aim. I mean, obviously, everything is very case specific, but we're just going through what is potentially could be indirect discrimination if other criteria remained out. Next slide, please. So discrimination arising from disability, this is a particular form of discrimination that only applies to the protected characteristic of disability. So it's, at first glance, it's difficult to see the difference, but actually there is some quite distinct differences between the other forms of discrimination and this form of discrimination. So what I've done is I've put in here the definition of disability. We didn't go through all of the definitions of the protected characteristics on the first slide deliberately because we only have an hour and a half plus questions and there wouldn't be time to go through it all. But obviously the definition of disability is very important because that's the protected characteristic that you will arguably come across most often. I mean, obviously race and gender reassignment and possibly sex is catching up, but certainly disability is the one that you'll be dealing with on a day-to-day basis, with the number of pupils that are being diagnosed with behavioural disorders. So we can see here under the definition of disability, this is actually in the Equality Act. And what I've done is it defines it and then it goes on to say what it means by that. And I've put it all together with brackets so that you can see the entire definition. So it's a physical or mental impairment which has a substantial and long-term adverse effect on the person's ability to carry out normal day-to-day activities. And then what the Act says is substantial, which sounds like quite a high test, is defined as simply more than minor or trivial. So, you know, it starts off up here and then suddenly it leapfrogs all the way down to here and becomes not a very high threshold at all. Long term is defined as meaning lasting or likely to last or recur for 12 months or more. So obviously this is not just lasting, it's likely, it's recurring. So even if you might only have the impairment for a month, if it's likely to crop up again in the future, and that would be more than 12 months in the future, then that could meet that definition. And I should stress that this doesn't mean that they have to have had the impairment for 12 months before it qualifies. It isn't like you get your badge after 12 months and now you're disabled. If it at the very outset is likely to last or recur for 12 months or more, then it will meet that limb of the definition. And adverse effect on the person's ability to carry out normal day-to-day activities for a school, all that means is normal day-to-day activities in the school. So there's no requirement at all you can see in there for a formal diagnosis. Obviously, if there is a formal diagnosis, it makes it very difficult to suggest that they're not disabled, but actually you don't need a formal diagnosis. And one of the pitfalls that schools regularly fall into, and we have this said to us a lot, is, oh, well, you know, we do accept that they've probably got something like ADHD or whatever, but they've never been assessed, the parents aren't cooperating, so they don't meet the definition. That doesn't matter. If they're either disabled or they're not, as a matter of fact, and there's no need for a diagnosis, so they would still be disabled before getting the diagnosis. The fact that the parent's not cooperating with an assessment, and they may even be denying that their child has anything wrong with them whatsoever, that's quite common, doesn't mean that the child isn't still disabled and protected under the Act. The safest thing to do is, if you believe that the child may meet this definition, if it's borderline at all, is to act in a way consistent with your equality duties. You don't necessarily have to label them as such. You don't have to say, right, we're treating you as disabled, we're going to start making reasonable adjustments for you and assessing whether or not you're at particular disadvantage under our policies. You just have to make sure that what you're doing is consistent with the Equality Act, so that at a later date, if it transpires they are disabled and an allegation that you haven't met your duties is made, you can say, well, actually, we were making adjustments. We may not have called them reasonable adjustments, but actually all this support that we put in place, all of these differentiations we gave, were reasonable adjustments for this child because of their disability. And the other thing that the Act requires is that you must have actual or deemed knowledge of the disability. What deemed knowledge means is that you are reasonably expected to know about it. And the problem for schools is you are considered to be experts in dealing with pupils with behavioural disorders. So you're experts in dealing with pupils with ODD, ADHD, ASD, all kinds of behavioural disorders, most commonly these days SEMH needs. And we feel that most pupils with SEMH needs will probably meet this, frankly, quite low threshold definition for a disability. At the very least, it will be safer to treat them as meeting this definition. Therefore, it would be very difficult for you to say that you don't have knowledge, because being viewed as people experienced of dealing with pupils that have these kinds of conditions means that you're likely to be found by a tribunal to ought to have known. So where it says reasonably expected to know, take that to mean reasonably ought to have known. It's very difficult for you to say you didn't have knowledge. And we have some cases where the school's been pushing for assessment and the parents have been blocking that, not being cooperative. In those circumstances where you're the one who's been pushing for them to be assessed by an EP or CAMS or whatever because of behavioural problems, it would be very difficult for you to subsequently say, but we didn't have any knowledge of the disability. You may not know the actual labelling of it and have had the report with all the recommendations, but you were the one pushing for assessment in the first place. So you did have at least deemed knowledge that there may be a disability there. Next slide, please. So, discrimination arising from disability, having gone through the definition of disability. So this is where it gets slightly different. So pupil A is treated unfavourably by the school. So you'll recall that in relation to the first slide on direct discrimination, the pupil had to be treated less favourably. And that might not sound like a big difference, but the point is that here we don't need a comparator. we only need to demonstrate that we have been treated unfavourably, not that we've been treated less favourably than somebody else that doesn't have our protected characteristic. This is why discrimination arising from disability is quite common in tribunal claims, because it's much easier to be able to demonstrate than when you're looking for a group of comparators and then you have to prove that you were also treated less favourably. So the unfavourable treatment has to be because of something arising in consequence of the disability. So there we're thinking of things that manifest from a disability. So I know we're harping on about the behavioural disorders, but this is because schools generally don't have a problem dealing with physical disabilities. They know if they're dealing with a pupil that's diabetic, asthmatic, in a wheelchair, etc., it's very easy to meet your duties. You know they're disabled and you know what you need to do to meet your duties. It's the behavioural disorders, the mental impairments, if you like, that is where schools struggle. So if you think about the things that can arise in consequence of that, well, as I said earlier, pupils with ADHD, for instance, I mean, obviously it's a case-by-case basis. It's not the same for every pupil, but it is quite common for them to be described as being easily led or easily influenced, not able to recognise the seriousness of their actions or the consequences of their actions. There are a variety of indirect symptoms of impairments that may well impact on a pupil's behaviour and put them at a particular disadvantage under your behaviour policy. So you can see why this is quite commonly used by parents who are alleging that schools have discriminated against their child, usually because of the imposition of the behaviour policy, but it can be other actions such as directions to alternative provision, just any decisions that you make really, that they consider to be unfavourable treatment. Again, you can justify the treatment. So even if they have demonstrated they're disabled, they can demonstrate that they have been treated unfavourably, and they can demonstrate that that was because of something that arose in consequence of the disability. If you can justify that the treatment was a proportionate means of achieving a legitimate aim, and obviously I'll refer you back to the previous slide on objective justification that sets out everything that you have to consider there, because it's exactly the same. If you can justify it, it won't be discriminatory. So unfavourable just means put at a disadvantage. That's all it means. So it's quite easy for that to be demonstrated. Again, most of these cases hinge on proportionate means of achieving a legitimate aim. Now, as I said at the beginning of this particular slide, there is no need for a comparator. You just need to demonstrate that treatment is unfavourable and is due to something arising from a disability. Now, in terms of proportionate means of achieving a legitimate aim, tribunals have a specific way of looking at this, and we will look at that slightly later in another slide, as to how the tribunals assess whether or not sanctioning that pupil, applying the policy to them, making a decision in relation to a direction off site or something like that was a proportionate means of achieving a legitimate aim. Next slide, please. So now we have a poll on disability, discrimination arising from disability. So again, 20-30 seconds on this one. So a pupil with Tourette's syndrome is given a detention for swearing in class. A pupil on the SEN register is placed in the school's pupil support unit. A pupil in a wheelchair is placed in an off-site setting for repeated low-level misbehaviour. And a parent with mental health difficulties is banned from the school site for reacting angrily when told that her child is being suspended. Which of these could be examples of discrimination arising from disability? Fabulous. So everybody believed that the pupil with Tourette's would be discrimination arising from disability, and that's obviously an obvious one because everybody knows that Tourette's causes swearing. So giving them a detention in class for swearing would be treating them unfavourably because of something arising in consequence of their disability. So a pupil on the SEN register is placed in the pupil support unit. Now, we don't know whether this is going to be discrimination arising from disability, because obviously just because they're on the SEN register doesn't necessarily mean that they are disabled. There is a close relationship between pupils with special educational needs and pupils with disabilities. So if you imagine the two charts that merge in the middle, there's obviously a very big merging in the middle. Many pupils with an EHC plan will meet the definition of disabled. But there are pupils who are on the SEN register or have EHCPs who aren't disabled, and there are many pupils who have behavioural disabilities who don't have recognised SEN. Probably not a great deal, because most of the behavioural disorders manifest themselves in special educational needs. But we don't know whether this pupil on the SEN register is actually disabled, and we don't know why they've been placed in the school's pupil support unit. It potentially could be classed as, or argued by the parents, to be unfavourable treatment. We just don't know enough about it. And obviously the pupil support unit is something that the DfE now includes in their behaviour guidance as something that schools can use in prescribed circumstances for intensive support. So the school could well justify that A isn't unfavourable treatment, and B is a proportionate means of achieving legitimate aim. A pupil in a wheelchair is placed in an off-site setting for repeated low-level misbehaviour. Well, here, some people thought that could be discrimination arising in consequence of disability. But of course, there doesn't appear on the face of it to be a link between being in a wheelchair and persistent repeated low-level misbehaviour. If they are disabled, they're in a wheelchair, they're disabled, they can't walk. Does that cause low-level misbehaviour? It may well be that the school decides that there's absolutely no link between the disability and the actual behaviour. If there's no link, they're not relevantly disabled. They wouldn't be able to. They wouldn't be able to demonstrate that is unfavourable treatment because of something arising in consequence of their disability. A parent with mental health difficulties is banned from the school site for reacting angrily when told that her child is being suspended. Well, we had quite a lot of people say yes, they thought this was, and I'm really pleased about that, because it's sometimes hard when dealing with all of these pupils that you're dealing with to remember that you also owe equality duties to parents and others as well. And obviously, if the parents with mental health difficulties are the ones that are hardest to deal with and the ones that cause so much frustration for schools. And obviously, if you suspend a child, parents are likely to react angrily anyway, but that is probably likely to be much more if they have mental health difficulties. Now, those mental health difficulties could potentially be a disability, because obviously, as we say, the threshold is not high at all, and there's no requirement for a diagnosis. If you are aware that they have recognised mental health difficulties, they're likely to meet the definition. It's probably foreseeable that they're going to react angrily when told the child's being suspended. That could well be a manifestation of their disability, and you need to make allowances for that. You need to understand that could be something arising in consequence of their disability, and not necessarily react to it in the same way you would with another parent who doesn't have mental health difficulties. Next slide, please. So the duty to make reasonable adjustments, this is section 20 of the Equality Act. There is, as I said, a strong link between the duty to make reasonable adjustments and indirect discrimination, because the first of the ones that apply to schools do relate to PCPs. There is actually 3 limbs to the duty to make reasonable adjustments, but one of them doesn't apply to schools. Of course, it only applies to disability, so all of the other protected characteristics, yes, you will be under a duty to adjust for another protected characteristic, but that's under the duty to avoid indirect discrimination, not under the duty to make reasonable adjustments. This only applies to disability. The 2 of the limbs that apply to schools, the first of these is where a PCP, so policy, criteria and practice, unwritten, unspoken, or written, or spoken, or published, puts disabled pupils at a substantial disadvantage here instead of particular compared with others. The school must take reasonable steps to avoid that disadvantage. And then the second limb is where not providing an auxiliary aid puts disabled pupils at a substantial disadvantage compared to others without it, the school must take reasonable steps to provide that auxiliary aid. So auxiliary aids aren't defined by the Act, but the guidance says that they are not just aids, they're also services. Anything that constitutes additional support is capable of being an auxiliary aid, such as equipment or support from a staff member. I mean, it could also be an interpreter, documents in Braille. There is, one-to-one support workers. All of these are auxiliary aids or services. And if the pupil is at a substantial disadvantage without it, you've then got to consider whether or not it is reasonable for you to provide it under the duty to make reasonable adjustments. Substantial, again, you think, oh, substantial disadvantage, that's quite high. Well, it isn't, because again, it's more than minor or trivial. So again, it starts here and then it drops right down. So, I don't think there's much difference between substantial disadvantage and particular disadvantage. It's just simply disadvantage, really. So this is an anticipatory duty that continues. And this is the difference between indirect discrimination and the duty to make reasonable adjustments. So indirect discrimination is obviously where you have a policy, criterion or practice that almost accidentally puts a category of persons with a protected characteristic at a disadvantage. You need to then adjust that policy in order to avoid that disadvantage, unless you can justify it as a proportionate means of achieving a legitimate aim. But really, it only really crops up when you're put on notice that these persons with a protected characteristic are at a particular disadvantage. The duty to make reasonable adjustments is anticipatory. You are under a duty to think about this in relation to disabled people in advance. You don't wait for them to come along and ask for a reasonable adjustment. They don't have to ask for a reasonable adjustment to be made. I mean, obviously, if you haven't thought about it, it's not something you would consider. And they come along and say, well, actually, it'd make my life easier because of my disability if you did this. That doesn't mean you failed in your duty to make reasonable adjustments because you didn't come up with it. It may be that they've got far more insight in relation to their disability than you have. However, you do need to be thinking about this in advance. For disabled pupils, you need to be thinking about what auxiliary aid you need to be providing, what PCPs are putting them at a disadvantage, and then you need to be considering whether it's reasonable to take the steps or provide the aid that you have identified would alleviate the disadvantage. I do sometimes think that shortening it to the duty to make reasonable adjustments doesn't emphasize the word reasonable enough. Really, it's a duty to make adjustments when it's reasonable for you to do so. Next slide, please. So obviously what that means is the key word is reasonable. So if you think about it logically, you have the following questions to ask. Are they disabled? Yes. Are they at a substantial disadvantage because of the absence of an auxiliary aid or under a PCP? Yes. Is there an adjustment or an auxiliary aid that we could provide that would alleviate or avoid that disadvantage? Yes. The next question is it reasonable for us to actually make that adjustment or provide that auxiliary aid? And what again, there's no help in the actual Act, which is not uncommon with Acts. They don't give you chapter and verse on how you have to do things. But in the technical guidance, and this is the technical guidance for schools on the duty to make reasonable adjustments for pupils, so it's very much targeted at the education sector, and it is specific to schools as well, not higher education, further education, independent schools, it's state-funded schools. They set out these factors that you can take into account, and it's not an exhaustive list. Now, I've put them in a different order simply because I needed to get a nice little slope on my writing and it wouldn't fit on the slide without it. So you might think that they're perhaps not in a logical order. But you can take into account, and I'll pick these out straight away, you can take into account the financial and other costs of making the adjustment or providing the auxiliary aid or service, and the school's resources. And it goes on to say, and how many of these resources have already been dedicated to making reasonable adjustments for others or for this particular pupil. And I'll pick that out straight away because, of course, we have a lot of schools that because of the relationship between SEND provision and making reasonable adjustments, obviously many things that you do as SEND provision will actually be also a reasonable adjustment. The two are interchangeable. So if a pupil has an EHCP and the EHCP provides for a one-to-one support worker, then obviously that one-to-one support is SEND provision, but it is also a reasonable adjustment under the Act. It qualifies as both. But that causes confusion sometimes for schools, because they, especially where there's an EHCP or there's high needs funding in place, schools can get into the habit of thinking, if it's not funded, we don't have to provide it. And of course, under the Equality Act, you are required to make and fund these adjustments. And it doesn't hinge on whether or not you're getting funding from the local authority. So you wouldn't be able to say it was unreasonable for us to make this adjustment because it wasn't funded under the pupils' EHCP. That's not to say that you couldn't take that into account. And if it was a very expensive adjustment, of course you can take cost into account, but there are a variety of adjustments that are recognised as being almost routine adjustments in schools that you would need to make. And when it comes to considering the cost of an adjustment, there was a case, I think a couple of years back, I can't remember the name of it off the top of my head, but there was a case that crawled all over a school that said it was unreasonable for it to make these adjustments on the grounds of cost. And the court actually delved into their entire school budget and how it was dedicated, how they divided it up, how they dedicated some of it to high needs, what they did with their pupil premium, what they did with their high needs funding, etc., the notional funding for SEND funding for children. And they really looked into the entire picture that the school was under and found that the arguments that were being made didn't actually stack up when it came to the what their whole budget was. So you do have to be clear when you're using cost as part of your reasons. I mean, obviously, if it's an incredibly high cost, it could be your entire reason for deciding that it's unreasonable. I mean, for instance, it wouldn't be reasonable to expect you to provide a all singing, all dancing motorised wheelchair for a child that can't walk, because of course that would have already been provided under health care anyway. But you know, as an extreme example, you're not going to be expected to pay for an incredibly expensive piece of equipment that you could reasonably expect them to have been provided for elsewhere. But at the same time, one-to-one support workers aren't cheap, and that is regularly found to be a requirement, an adjustment that it is reasonable to make, subject to whether or not you have the funds for it, and that doesn't necessarily mean the local authority is paying. You can take into account how that they are getting SEND provision in accordance with your duties under Part 3 of the Children and Families Act 2014. But as I say, it's not a get out of jail free card. You can't say, well, we don't have to provide it as SEND provision, therefore it's not a reasonable adjustment. You can maintain academic, musical, sporting and other standards. So what that means is you're entitled to pick the best pupils for teams, etc. You wouldn't be required to adjust your policy to put a pupil in a wheelchair on your able-bodied football team, as long as you were including them in PE and football ordinarily. You were entitled to select according to standards. You can take into account the interests of other people and other pupils and prospective pupils in terms of trying to consider whether or not an adjustment is reasonable or an auxiliary aid is reasonable. But you can only take that into account if they would be, quote, significantly disadvantaged. So they've caveated that somewhat. You can obviously take into account whether or not the adjustment is actually going to be effective, and if so, how effective. I mean, obviously that's proportionality. If it's going to cost you quite a lot of money and quite a lot of effort and cause a lot of disruption in a class, but actually the benefit to the pupil is quite low, then that is a factor you can take into account when deciding whether or not it's reasonable to make it. You can consider the effect of the disability on the pupil. I mean, if the disability doesn't actually have a major effect on the pupil, it's very, very mild. That doesn't mean your equality duties don't count, but it can be a factor that you take into account in deciding whether it's reasonable to make a particular adjustment. And then obviously you can consider health and safety and the practicability of making the adjustment. These, as I said, are a non-exhaustive list, but they are in the guidance, so it would be helpful when you are, I mean, the main thing that you need to do in equality is when you make your decisions, you need to make considered decisions that are designed to address the actual criteria that you're trying to avoid falling into. And then you record your decision and the reasons for it with reference to these kind of factors. Because if somebody comes along later and says, you didn't comply with your duty to make reasonable adjustments, the duty isn't to make the adjustment per se. The duty is to have regard to your duty to make reasonable adjustments. If you've considered the duty and you've made a decision that you're not making this adjustment, and these are your reasons, and they are actual valid reasons, and you've recorded it and you've got it in your audit trail, you are going to be able to defend an allegation. It may be that a tribunal decides at a later date that actually it was an adjustment that was reasonable to make, but you'll have put yourself in a very strong position. First, you'll be able to demonstrate that you did actually consider it. And secondly, you'll be able to actively give contemporaneous evidence of what you considered at the time and the factors you took into consideration. Next slide, please. So I think this is the last of the polls. We do have some more polls, but they're linked to a case study later. So more in relation to questions relating to a case study. But this is the last of the polls where you're asked to choose which you think might be a reasonable adjustment. So this is just a list of things that you might do, interventions that you might do, and we're just interested in knowing what you think could be a reasonable adjustment. So we have timeout card, one-to-one support worker in all classes, fiddle toy, one-to-one support worker at an after-school football club, not being sanctioned for a breach of the behaviour policy, a differentiated timetable, a one-to-one support worker on a residential school trip, not being permanently excluded for a drug possession breach, and a part-time timetable. So just a few seconds for you to choose all that might apply. Oh, fabulous. This is great. Right, okay, so timeout card. I think practically all of you understood that giving a pupil a timeout card is an adjustment that is likely to be reasonable to make. I mean, obviously, pupils that aren't disabled, pupils that don't have behavioural disorders, I mean, obviously, that's not to say that you wouldn't necessarily give timeout cards to pupils that just have problems with concentrating in class. They might not all be disabled, but that is an adjustment because pupils are not usually allowed to just leave class. So giving them a timeout card is adjusting your policy, your unwritten policy that pupils should stay in class during lessons. One-to-one support worker in all classes. Now, what I did was I slotted in one-to-one support worker in all classes and one-to-one support worker at an after football club and one-to-one support worker on a residential trip. And I'm really glad that you didn't actually fall for the later ones, because what usually happens is schools think that at an after school club or on a residential trip, there wouldn't be a duty to provide one. Well, they are potentially reasonable adjustments. I mean, a one-to-one support worker on a residential school trip would come down to whether or not it's reasonable to be able to do it. I mean, we've had some schools where they just don't have a one-to-one support worker because the pupil has a named one-to-one support worker who doesn't want to go on the residential school trip and can't be compelled to, and they haven't been able to find anyone else to do it. So, you know, even looking at trying to employ a locum, if you like, one-to-one support worker, but, you know, taking into account that they're not properly trained with the pupil's needs and don't have a relationship with them. But these are just potentially reasonable adjustments. Now, with the after school football club, that would depend on whether or not the school is running the after football club or it's subcontracted out to whoever's running it. If they have literally just rented their fields to a completely separate football coach who runs an after school football club for your pupils and any other pupils that want to apply, then it's for that coach to make reasonable adjustments for the pupil and not the school. I mean, that wouldn't stop parents from perhaps saying, well, it's on your school site, you should be responsible for it. But I have acted for a school before that had a disability discrimination claim consisting of a number of different allegations, and one of them was that a one-to-one support worker wasn't provided at an after-school club, and that resulted in the pupil being told he couldn't come back to the after-school club. And the judge made the point that this wasn't a football club run by the school, it was simply a letting situation, and that actually that claim didn't succeed against the school because it wasn't their duty to make reasonable adjustments there. He did say perhaps the parents might like to go after the person who ran the school football club, and of course, because that isn't a school situation, they would be able to go after that person in the county court or the other civil courts and include a claim for compensation, because obviously it's only claims relating to pupils in schools that have to be dealt with by the tribunal that doesn't have the power to award damages. So obviously fiddle toy falls into the same category as timeout card. I mean, if your disability causes you to fidget, a fiddle toy might be an adjustment. Differentiated timetable, well, clearly everybody went for that, and yes, it can definitely be an adjustment. You might have small group work or one-to-one mentoring or something like that to meet your needs. Not being permanently excluded for a drug possession offence. Well, again, it comes down to whether or not the drug possession offence has any link with the disability, because it may well be that there isn't a link. Just because a pupil has, for example, ADHD doesn't mean to say that that caused them to be in possession of drugs. There may be an indirect link, but we just don't know. But not being permanently excluded for something that others would probably be permanently excluded for is an adjustment of a policy that could be a reasonable adjustment for a disability. Part-time timetable, we've got 94% saying, yes, this is a reasonable adjustment. You need to be really careful with part-time timetables, because often when we say to schools at the outset of a disability discrimination claim, please can you let us know what adjustments you've been making, what interventions have you put in place, what support have you done for this pupil, who have you contacted for help, which reports have you got, have you followed all recommendations, etc. Often the list will come back and part-time timetable will be on it, but also often part-time timetable will appear as unfavourable treatment on the parent's list of allegations to the tribunal, because the parent will invariably say, I didn't want my child to go on a part-time timetable, I was told it was that or permanent exclusion, so I had to agree to it. So there are issues over whether or not it's appropriate anyway to suggest that the parents consented to it. But the problem with the part-time timetable is, if the part-time timetable has been put in place because the school can't cope with the behaviour, rather than the pupil's disability, i.e. / medical condition, means that they're not capable of attending in the same way that any medical condition might prevent them from attending, then it's not going to be a reasonable adjustment, and it's potentially going to be a prohibited act, i.e. unfavourable treatment, to put them on a part-time timetable. And the DfE is actually beefed up, not enough in my opinion, but beefed up its advice slightly in the attendance guidance and the behaviour guidance to say, again, that part-time timetables really shouldn't be used as an intervention or as a response to bad behaviour. They are to be used for a limited time only in cases where the pupil is incapable of attending school. Okay, next slide, please. So Rose is now going to take you through quickly harassment and victimisation. We don't come across it a lot, so she's not going to dwell on it for too long.
Yeah, absolutely. So looking very briefly at harassment, so under the Equality Act, there are 3 different types of harassment, and we've set these out for you here. So there'll be harassment related to a relevant protected characteristic, and we'll come back to what relevant protected characteristic means in just a second. Sexual harassment and less favourable treatment, either because of submission to or rejection of sexual harassment, and or harassment related to the protected characteristic of sex. So again, we have some differentiation here. And so for schools, the relevant protected characteristics are disability, race, and sex. And we've included these as a reminder on the slide for you. And so we have these three different types of harassment, but what does harassment actually mean under the Equality Act? Well, it's unwanted behaviour that has the purpose of violating a pupil's dignity, or it creates an environment for the pupil that is intimidating, hostile, degrading, humiliating, or offensive. And so the word unwanted here is really about thinking about unwelcome or uninvited behaviour. And if we go back to that first type of harassment related to a relevant protected characteristic, it is important to note that the Equality Act actually affords this quite a wide definition. And so it could even be that the person is associated with someone with that protected characteristic. Now, as Jo said, we're not going to go into huge amounts of detail on these, but these will be included on the crib sheet for you that will be sent out later. So Tamar, if I could have the next slide, please. And we're then going to move on to look at victimisation, which is section 27 of the Equality Act 2010. And so here again, we do have some differentiation in the definition for schools of victimisation, and where a pupil is subjected to a detriment because either they, the pupil, or their siblings or parents have, or the school believes they have, carried out a protected act. So we've set out for you below the list of what the Equality Act tells us are protected acts. So for example, either, and this may be a more common one, making a claim or complaining of discrimination. So for example, the parent brings a claim in the first tier tribunal, making an allegation, or doing anything else for the purpose of or in connection with the Equality Act 2010. Now, importantly, there is no protection under the victimisation provisions if that information has been given falsely and in bad faith. And that's slightly different here in comparison to a scenario where there is a claim or complaint of victimisation, but it hasn't been upheld. And so for people to be able to show that victimisation has occurred, there needs to be a demonstrable link between the detriment that they have suffered and one of those protected acts. So that's a very swift run through of those two provisions, and I'm now going to hand you back over to Jo as we look at the school-specific provisions in the Equality Act.
Next slide, please. Fantastic. Right, so there are some specific provisions in the Equality Act 2010 that relate solely to education, and in the main, the most important ones are the ones related to admission and the ones related to exclusion, and it still refers to exclusion, although obviously the terminology is now changed to suspension and permanent exclusion. So in relation to admission, what the Act says, it is unlawful to discriminate against or victimise a person in the arrangements it makes for deciding who is offered admission, as to the terms on which it offers admission, or by not admitting them. So essentially what that's saying is you cannot discriminate against pupils in relation to the admission arrangements in school. Now obviously the crucial word there is discriminate, so we're talking unfavourable treatment or less favourable treatment. Now there are some exceptions, so single-sex schools are able to say we only admit boys or we only admit girls. Now obviously that has thrown up a few questions recently, mainly in relation to the admission of transgender pupils, and we've had quite a few single-sex schools, especially since the big case that blew up in the summer of this year, I think it was. It may have been longer ago than that because time seems to fly at the moment, but since the case hit the press about the school, a group of single-sex independent schools who actually published a policy that said we are not going to admit any pupils who were not born female. that threw up the question of was that lawful? Because obviously here we've got the competing protected characteristics of gender reassignment and sex. So schools are designated a sex, and the default position is that you would admit pupils, applicants who were assigned that sex at birth. Now, obviously, if they're assigned that sex at birth, but they now identify as the opposite sex, you would still admit them because they're assigned that sex at birth. But the question is, what do you do about those that were assigned the opposite sex at birth, but who now identify as your school's sex, designated sex? and what the argument was against the policy in the case that hit the press was that the Equality Act actually, sorry, the admission law actually says that single-sex schools won't lose their status if they exceptionally admit pupils of the opposite sex to their designated sex, or if they admit pupils in comparatively small numbers on specific courses. So essentially that would cover a situation where often single-sex schools, you usually find with single-sex schools, certainly in the state sector, that if there is a single-sex school for boys, there's usually one very close by for girls as well. And often they have a mixed sixth form at both schools. Sometimes they have a shared sixth form, so one sixth form offers some subjects and the other sixth form offers other subjects, and the pupils move between the two depending on what A-level subjects they wanted to do. And sometimes they just have a mixed sex sixth form, so pupils from the other school could apply to attend the boys' school, so girls could essentially apply to attend the boys' school. So that would cover the situation where you're admitting in comparatively small numbers on particular courses, but you can also admit pupils of the opposite sex exceptionally anyway. And what the argument was against the one that hit the press was that it's not unlawful for you to admit pupils that were assigned the opposite sex at birth. So why are you not doing it? You aren't doing it purely because you don't want to admit transgender pupils. I mean, it's a bit of a hot topic at the moment, and we don't quite know where it's going, because obviously we are waiting for this advice on transgender that I referred to at the outset. But the way we see it at the moment is you're not legally obliged to admit pupils that are assigned the opposite sex at birth, but you are legally able to. So it does create a bit of an anomaly, because if you do admit pupils that were assigned the opposite sex at birth but now identify with your designated sex, as well as admitting pupils that were assigned your designated sex at birth but now identify with the opposite sex, you're obviously then in a situation where these transgender pupils are able to apply to both of the schools, whereas pupils that aren't transgender can only apply to one or the other, which is a weird anomaly, but that doesn't necessarily mean it shouldn't happen. But yes, it's a question of watch this space, because we are hoping that's one of the things that will be addressed when the DfE publishes its long-awaited guidance. Obviously, faith schools, there's an exception, because they can give priority to pupils in their admission arrangements based on faith. I'm not an employment lawyer, but they can also, I believe, recruit staff of the designated sex in prescribed numbers, as not sex, sorry, faith, in prescribed numbers as well. That's not something that I'm an expert in, but certainly there are exceptions that allow them to prioritise those of the faith. Obviously, in relation to admission arrangements, we have already discussed, and one of our poll questions was adjusting admission arrangements to avoid indirect discrimination or as a reasonable adjustment. For example, minimum academic entry criteria, adjusting the threshold at which you allow pupils into year 12 to take into account a disability that may have adversely affected the pupil's grades. I mean, obviously you'd need to be very careful about doing that. You'd need to make sure that you have a way of assessing what their grades should have been but for the disability. It's not a get out jail free card. We want to admit this pupil, we're just going to say it's an adjustment. You need to identify that there was a disability, that the disability caused substantial or particular disadvantage in the application of minimum academic entry criteria, and it is reasonable for you to make the adjustment to essentially lower your threshold for that pupil, because obviously it could be challenged by others who were refused entry because they didn't meet the minimum academic entry criteria. Next slide, please. So then we move on to the provisions relating to what they refer to as exclusion, but we now call suspension and permanent exclusion, which I've referred to as PECs here. What the Act says is it is unlawful to discriminate against, harass or victimise a pupil by excluding them from the school. Now, unfortunately, this often gets misinterpreted by parents, and it seems those advising parents, mainly charitable organisations that don't take any money for advising them, because they lose sight of the word discriminate there, and they think that what it says is if they have a protected characteristic, you can't exclude them, and obviously this usually relates to disability. But the word that is important again is discriminate, and discriminate means direct, indirect, or discrimination arising in consequence of disability. So we are talking unfavourable treatment, less favourable treatment, or treatment that has arisen from the disability. So what it actually says is it is unlawful to treat someone unfavourably or less favourably, or to harass them or victimise them because of their disability by excluding them. So that's what it essentially says. So it does apply to all protected characteristics, but it does most frequently arise with disabled pupils, because obviously we're talking about suspension and PECs, and you could have a situation where somebody has been suspended because of a hairstyle, so that could be religion or belief, or it could be race. So there are other protected characteristics that it could apply to, but most commonly it is disability. Next slide, please. So this slide deals with how you should approach sanctioning pupils, disabled pupils, and how the first tier tribunal will approach it. And the reason we're going through it like this, taking this practical approach, is because we deal with a lot of discrimination claims, disability discrimination claims. Now, discrimination claims for all of the other protected characteristics, except disability, will take place in the civil courts, and they will include a claim for damages. And in fact, they probably won't include much else. I mean, I suppose they could ask for an injunction, but it would be difficult for them to ask for the wide range of remedies they can get from the tribunal. It would simply be suing you as they would for personal injury or something like that, but they're doing it for race discrimination or sex discrimination or whatever, and they would be seeking compensation. But disability discrimination, when it relates to pupils in schools, have to be brought in the first tier tribunal, and that's the first tier tribunal SEN and disability. That's the same forum that parents have to bring SEN appeals against local authorities who manage and maintain and issue EHC plans. So it was just felt that forum, those judges, were best placed for dealing with disability discrimination claims. But it has created something of an anomaly, because what that means is that parents can't go for compensation, because the first tier tribunal do not have the power to award compensation. They do have the power to award almost anything else they want to. I mean, there are some things they can't. They can't order a school to sack someone, for example. They can't order another school that's not a part of the proceedings to admit a pupil. There are things that it's just simply not lawful for them to do, but they have a wide discrimination. They can make a declaration of disability discrimination. They can direct reinstatement, and this is something that needs to be considered, because obviously independent review panel hearings, the independent review panel doesn't have the power to direct reinstatement. All it can do is make the governing body reconsider its original decision to decline to reinstate, in the hope that they make a different decision. But first tier tribunal can direct reinstatement, so parents will often go to the first tier tribunal after losing an IRPH or winning an IRPH, but the GDC still declines to reinstate on reconsideration. Or what we see quite a lot is, because of the 6-month limitation period, often they will actually issue a claim in the first tier tribunal at the same time as asking for an IRPH, and then tell the IRP that they've issued a claim for disability discrimination, which frankly quite often scares the bejesus out of these IRPs and makes them very worried about making the wrong decision. So it's quite a tactical advantage sometimes to say we've put in a claim for disability discrimination. No IRP would want to make a decision and then consequently have that decision torn to pieces by a tribunal judge. But we are seeing lots of these claims. Most schools are covered for legal expenses on them. Some of them aren't. If you're covered by the DfE's risk protection arrangement, you will be covered for legal expenses, and you do want to be, because they are becoming increasingly common and they will cost you quite a lot of money in legal fees to defend all the way to a final hearing. They're also incredibly burdensome in terms of the fact that the timetable, in contrast to civil claims, is set at the beginning. It's usually a very, very intensive 4-month period. They set the final hearing date and then they set about 4 or 5 directions before then. You've usually only got 5 weeks, 4 or 5 weeks before the first direction, which is the most onerous. And so it literally is like getting on a roller coaster and not getting off for 4 months. So they are to be avoided at all costs, especially if you don't have insurance for the legal fees. And they're very, very, very stressful for staff, for head teachers, for governors. So in terms of sanctioning disabled pupils, the first thing I've said is it isn't unlawful on the face of it to sanction disabled pupils, contrary to what some parents might think. You can lawfully sanction disabled pupils. You just have an awful lot of ducks to get into a row before you can demonstrate that it's lawful. So all sanctions, and potentially, as I said earlier, placements in a pupil support unit or alternative provision, directions off-site, can be argued to be unfavourable or less favourable treatment. So all of them are capable of being argued to be misconduct. And we frequently deal with disability discrimination claims where there's a variety of things. There's detentions, there's suspensions, probably culminating in a permanent exclusion, but there may well be an off-site direction. There might be quite a lot of internal seclusion or isolation. All of these things can be argued to be unfavourable treatment, less favourable treatment, and a failure to make adjustments to the policies. So how do the first tier tribunal approach disability discrimination claims? The majority of them are indirect discrimination or failure to make reasonable adjustments, which is basically not adjusting your policies, mainly your behaviour policy. But also it may be a failure to provide auxiliary aids, which is a failure to make reasonable adjustments. And a lot of the time there will be allegations of disability discrimination arising from disability, because obviously they don't need to find comparators or a PCP. They can just say, well, I've been treated unfavourably because of something that was caused by my disability. Now, we've been through how you justify indirect discrimination and discrimination arising from disability by saying that it was a proportionate means of achieving a legitimate aim. So we went through that in some detail. What a tribunal will do is, in order to assess whether or not the school's actions were proportionate, they will look at everything the school did in the run-up to whatever happened that led to the unfavourable treatment, the treatment that's being argued to be unfavourable or less favourable. So essentially what they'll do is they will look at all of the support and interventions and adjustments that the school has made for the pupil since they've had the pupil, or at the very least in the last couple of years, or since they developed the disability, for the relevant time period. And if they are satisfied that the school did everything they can to support the pupil, not just in terms of making all usual adjustments, twiddle toys, timeout cards, mentors, one-to-one support, everything that you can think of that you would do to support a pupil with additional needs, special education needs and disabilities in school, but that you also did things like, if there's an EHCP, you ask for an emergency annual review, multi-agency assessment, going to educational psychologists and other forms of external support, asking for reports, asking for recommendations, putting them in place, assessing whether or not they actually worked. If there was nothing else you could do, then you probably will be able to justify what you did as a proportionate means of achieving a legitimate aim. If there was stuff you could have done but didn't do, such as you got a report from the EP, they made a load of recommendations, but actually you didn't implement any of them. Instead, 2 days later, you permanently excluded them, you might not be able to justify it. I mean, obviously, everything is very, very much case specific. There are some incidents where, even if you haven't done everything that you could have done, the behaviour is such that it's still proportionate. But it is getting increasingly difficult to be able to justify suspensions and exclusions if the school hasn't done absolutely everything it could have done first. So not only do you need to be doing it, you need to be creating your audit trail of doing it. Next slide, please. So looking at this case study, and then we've got some a few polls that just ask some quick questions. We only need to give you 10-15 seconds on each poll. So Adam is in year 5. This is just us trying to give you some practical application, because obviously it can seem quite dry. Equality law is very much a heavy legislative law. The language is hard. We've tried to obviously make it less hard, but it does feel like a lot. So Adam is in year 5. The school suspects he has a behavioural disorder, but mum will not agree to him being referred for assessment. Adam is persistently disruptive in class. He won't sit still. He gets up and walks around. He continually shouts and talks. He sometimes hits and pushes other pupils without being provoked. The school has given him a twiddle toy and is sat him at the front of the class where the teacher can see him. They have been applying for additional funding unsuccessfully. Mum says Adam needs a one-to-one, as this helped at a previous school. There was nothing in the file from the previous school indicating he was on their SEN register or had a one-to-one. The school has 3 one-to-ones, but they are all allocated to full-time pupils with the HCPs providing for a full-time one-to-one. So if we go with the first poll, is Adam disabled under the Equality Act? It's just a single choice. Fabulous. Yeah, so he's either disabled or we don't know, but it's safer to treat him as disabled. I mean, at the end of the day, it's the school that suspects he has the behavioural disorder, and the fact that mum's not being cooperative doesn't matter. And it is safer, as I said right at the outset, to treat them as disabled if you think that they may be. So the next poll. Has the school put sufficient support in place for Adam? I mean, obviously, I appreciate you've got limited information here, but just on the information we've got, do you think the school has put sufficient support in place for Adam, a pupil they suspect has a behavioural disorder, who hasn't yet been assessed? Fabulous. I'm surprised that some people think they have put in place sufficient support. I mean, the reason for that is he's literally only had a twiddle toy and been sat at the front of class, even though he's not yet been assessed. So you haven't had the benefit of knowing if he does have a particular behavioural disorder. From experience alone, you would probably know that there are other adjustments that you could consider making to see what happens, other SEN provision you could put in place to see what helps. You would be able to use your experience of dealing with other pupils with behavioural disorders to be able to put more support in place for him than that. You shouldn't wait until he's been assessed or use the fact that mum's not being cooperative as a reason to not put in place the support. Next poll, please. So can the school sanction Adam for hitting and pushing other pupils? Now, what I didn't say on my previous slide, unfortunately, I'm set up in a room in the office and I didn't realise that our notes at the bottom wouldn't be accessible to us. So we haven't got the aid memoirs that I put at the bottom of the slides to look at. But what I didn't say is some of you may have heard of this exception that is contained in the Equality Act that says a tendency to physical or sexual abuse of others is not to be considered an impairment capable of being a disability. I mean, obviously that's not in the education specific provisions, it's in the main provisions, and it's talking about disability generally across the entire population. And it's a policy decision, because obviously what they're saying is if you have a tendency to physical or sexual abuse of others, you're not going to be able to argue that's a disability. There's a whole list of them. I mean, there's also a tendency to set fires, a tendency to, I don't think it's steal. The rest of them aren't really relevant for this purpose. But what happened was there was a case, the case of C, a few years back now, it's probably pre-pandemic, where it went to the court because C had a behavioural disorder that meant that he was violent to others as a manifestation of that disorder. And what they were arguing was that it was totally unfair that the school didn't need to meet its equality duties whenever he was violent, when he did have a recognised disability. And in a nutshell, what the court found was, if you have a tendency to physical abuse of others and that is caused by a disorder that itself does meet the definition of a disability, you can't rely on this exception to exclude it. And what that means in practice is, whereas before, if you were suspending or sanctioning for purely physical abuse of others' behaviour, and it had to be a tendency, so there had to be some form of regularity, there had to be some form of repetitiveness, you could go ahead and do it without worrying about your equality duties. And that has actually stopped now. So in the context of me now telling you that, when I should have told you that on the previous slides, can the school sanction? Sorry, it's gone now, but never mind anyway. People have answered it anyway. So yes, so we've got loads of people saying yes they can, and then lots of people saying no they can't. The problem you've got is that we think he has a behavioural disorder, and that behavioural disorder may well metamorph itself into hitting and pushing others. Just because it's violent behaviour doesn't mean that you don't consider whether or not this is something arising from his disability. So the previous question was, have we put in place sufficient support for Adam yet? And the answer to that, we would suggest, is no. All we've done is give him a twiddle toy and sat him at the front of class. He's not been assessed yet. We haven't put in place any recommendations because we haven't received any yet. We're very much at the start of the journey. We won't be able to demonstrate that we have made all adjustments that it is reasonable to make for this boy who is probably disabled. That means that we're not going to be able to justify as a proportionate means of achieving a legitimate aim, unfavourable or less favourable treatment. And it's a big if, because we don't know what his disability is, and we don't know whether a manifestation of that is hitting or pushing others unprovoked. But if it is something that arises out of his disability, and we haven't put in place sufficient support to try and avoid that situation in the first place, it will not be lawful to sanction him, because that will be unfavourable or less favourable treatment that can't be demonstrated to be a proportionate means of achieving a legitimate aim. It's the proportionate part that we can't demonstrate because we haven't made all the adjustments it's reasonable to make yet. Next poll, please. So should the school consider allocating a one-to-one to Adam without SEND funding? So they've been applying for SEND funding, but they've not been successful. And they have 3 one-to-ones, but they're all allocated full-time to pupils with the HCPs that provide for a full-time one-to-one. So essentially, I suppose what we're asking is, should the school consider recruiting a new one-to-one without having any SEND funding for that, for Adam? Yes, so yes, I mean, it's a tricky one, this is, because obviously what it comes down to is reasonableness. So we don't know if this is a 10-form entry primary school or a 1-form entry primary school, or a primary school in a village that only admits 15 pupils and puts them in a joint year with year above. We have no idea what their budget is. We don't know if they're in deficit. We don't know anything like that. But what it comes down to is the questions that we went through earlier. Is he disabled? Well, we think he is. It's safer to assume he is. We're the ones saying he should be assessed. Is he at a substantial disadvantage because of that disability in the application of our policies, or without the provision of an auxiliary aid or service, which includes a one-to-one? Well, yes, he is, because look at his behaviour. If that's caused by his disability, then it's putting him at a substantial disadvantage, because that's the sort of behaviour that would usually get him suspended and then permanently excluded eventually. Is there something we could do? So is there adjustment we can, are there steps we can take? Is there an auxiliary aid or service we can provide that would alleviate or avoid that disadvantage at all? Well, we could provide a one-to-one, see what happens. Is it reasonable for us to do so? Well, that's the big question, isn't it? Do we have the budget for it? You know, do we have a surplus of funds and high pupil premium budgets up there waiting to be used, etc.? You may be able to justify not getting him a one-to-one in some circumstances if you can demonstrate it isn't reasonable for you to do so. And it could come down to cost in some circumstances. I mean, obviously, in a perfect world, you'd love to be able to just say, here you go, here's a one-to-one. But without the funding, the cost could be a factor you can take into consideration when deciding whether or not it's reasonable. And then obviously when you're petitioning the local authority for high needs funding, or potentially looking at trying to get him an EHCP, etc., then you would be saying he's at high risk of suspension and possibly permanent exclusion without a one-to-one, which we simply can't afford to fund without the funding from you. Next slide, please. So just quickly on accessibility plans. So the third duty to make reasonable adjustments that didn't apply to schools, so I didn't put it on the slide. The third limb of the duty was to make physical changes to your site, to your buildings, in order to meet the needs of disabled pupils. Now that doesn't apply to schools, so you're not under this duty to make physical changes to your site under the duty to make reasonable adjustments. However, all schools have to have an accessibility plan, and the accessibility plan has to contain strategies for increasing the extent to which disabled pupils can participate in the curriculum. And we're not just talking physically disabled pupils, we're talking behaviourally disabled pupils, as we have been talking throughout this session. So when we're talking about increasing the extent to which they can participate, we are talking about pupils with behavioural problems who are struggling to participate in the curriculum. Improving the physical environment of the school for the purpose of increasing the extent to which disabled pupils can take advantage of the education and benefits, facilities or services of the school. So that's where the duty does come in. Although you aren't under a duty to make very expensive changes to your school, because a lot of schools are obviously in very old buildings that you can't install lifts in, etc., you do have to have strategies for improving the physical environment of the school. And it might be things like moving your labs to the ground floor or putting in ramps or whatever, things that you can do without doing major reconstruction works. And then improving delivery to disabled pupils of information readily accessible to non-disabled pupils. So this would include information such as Braille, obviously audio, large print, the films that go over it to make it more accessible. So as I've said at the bottom, you're not currently required to make physical alterations, but you do need to take reasonable steps to address issues that you do identify in your accessibility plan. So the next few slides, the last few slides, you'll be thankful to know, are on the public sector equality duty. Now, I just wanted to say in relation to that before I hand over to Rosie, we often see, when we say to schools at the start of a disability discrimination claim, or more likely a complaint where the parent is alleging discrimination, or a letter from a local organisation alleging discrimination, we say to schools, please can you send us your equality policy? And then when we look at it, all it contains is the public sector equality duty. It doesn't contain anything about all of the other specific duties and the misconduct, which are arguably the main part of the Act. The public sector equality duty is a sort of secondary part of the Act. I'm not saying that it's not important, but it's a secondary part of the Act that only applies to the public sector. The rest of the Act applies to everybody and is really important. You will not find yourself in a first-tier tribunal accused of not meeting your public sector equality duty. You will only find yourselves in a first-tier tribunal accused of indirect discrimination, or direct potentially, but it's very uncommon, indirect discrimination arising of and failing to make reasonable adjustments. So yes, you do have to comply with your public sector equality duty, but that is not all that equality is about, which some policies seem to suggest it is. So Rosie's just going to very quickly go through the general duty and the specific duties of the public sector equality duty.
Thank you, Jo. So absolutely. So as Jo said, so the public sector equality duty, or you might have heard it referred to as the PSED, applies to all public authorities and everyone who's carrying out public functions. So it is this pervasive duty. And there are two parts to it, and you need to be considering both equally. So first of all, we have the general duty. And so that is your duty to, when making a decision, when exercising a function, you must be having due regard to the need to eliminate discrimination and prohibited conduct, to advance equality of opportunity between persons who share a relevant protected characteristic and those who don't, and to foster good relations between persons who share a relevant protected characteristic and those who don't. So it's important to note, as Jo touched on earlier, that this isn't a retrospective duty, and it is something that really needs to be at the heart of your operations to ensure that you are complying with all of your equality obligations under the Act. So if we could have the next slide, please, Tamar. So here we've just set out some more information for you about what having due regard actually means. And so this is your conscious consideration when you're making a decision. And it is, again, it's this proactive pre-decision, pre-function. So when you're looking at how you're going to have due regards to advance equality of opportunity, you need to be looking at how you can remove or minimize disadvantage, how you as a school are taking steps to meet those needs of those people with the relevant protected characteristics, and how you can be encouraging people who share relevant protected characteristics to be able to be participating fully in school life. So again, here we've got this phrase, relevant protected characteristics. And for the public sector equality duty, that is all except marriage and civil partnership. And of course, we already know that age doesn't apply to pupils in a school setting. So when you're considering the need to foster good relations, you need to be thinking about how, as a school, you are going to be tackling prejudice, how you're promoting understanding, and really that encouragement of relations, encouraging integration, and reducing those levels of prejudice within the school community. Could we have the next slide, please, Tamar? So alongside your general duty, the Act also requires that there's this specific duty. And the idea of this is that it is the practical application. So you must be publishing one or more equality objectives that you have identified you as a school need to be able to meet that general duty. Now, I've referred in this section here to school, and if you are a multi-academy trust, it is important to note that these objectives and considerations do need to be at school level, because it is likely that there are going to be different considerations for each school depending on the demographic, location, etc. So, as with all our objectives in life, these do need to be specific and measurable and be relating to one or more requirements of the general duty. So you need to be thinking about, as we've discussed a short time ago in relation to the general duty, what it is you can do as a school that will, for example, eliminate discrimination. Could we have the next slide, please, Tamar? And so here, this slide really sets out the practical elements of this. So as a minimum, and we say this, it's a minimum and not a target, schools must be publishing further objectives not every 4 years. These objectives should be clearly accessible to everyone, so to pupils and to parents. And they should be easily findable. For example, they may be, as Jo touched upon, in another policy. So it could be that you include these within your equality policy, together with all your other information, both on the public sector equality duty, as well as your other duties under the Equality Act. So that's very much a whistle-stop tour of the public sector equality duty. And so now we've got some time at the end for some questions. And so I'm going to hand back over to Jo, who's going to start with those.
So we've only actually been asked one question in the chat box. We should have said at the beginning, if you have any questions, please put them in the Q&A box. You can put them in the chat box as well, but chat box is really for technical problems and saying that you're going to go. But if anybody has any questions whatsoever, please pop them in the Q&A box now. So the question that we have had is, does the public sector equality duty require you to anticipate possible indirect discrimination? Now, this came in at the point that I was saying that the duty to make reasonable adjustments can be contrasted with the duty to avoid indirect discrimination on the basis it's a continuing and anticipatory duty. I think what I was trying to get across, I mean, obviously, as Rosie's just been through, you've got the three limbs of the general duty of the public sector equality duty, and the first one is eliminate discrimination. So obviously, yes, looking at it in the true sense of the word, the public sector equality duty does require you to eliminate discrimination, which would include indirect discrimination. However, what I meant was, on an individual student basis, you have an anticipatory duty on an individual student basis with disabled pupils to think about what adjustments need to be made in advance proactively and continue to think about it as time goes on. Rather than, whereas the public sector equality duty requires you to think about eliminating discrimination more on a general level. I mean, obviously with your indirect discrimination is a good example, because obviously we're talking about policies, criterions and practices, and you should be able to consider a policy and try to think hypothetically whether it would put anyone with a particular protected characteristic, a group of people with a particular protected characteristic at a particular disadvantage. But you may not know that they're at a particular disadvantage until they come along and say, actually, I'm at a disadvantage because of this. You know, so there isn't, it's all interrelated, yes. But the difference between it is that with the duty to make reasonable adjustments is it is an actual proactive, positive duty that you have to be thinking about in advance. So we have another question. Can you explain a little more on how to proceed with a child with disruptive behaviour when you don't have the support from parents? Well, it's incredibly difficult, isn't it? Because we come across a lot of cases where the parents have been obstructive in not wanting their child assessed because they don't want their child to be labelled. And then subsequently, that they have been quite happy to go along and allege discrimination in the first tier tribunal, despite the fact that they were the ones that were blocking it and saying at the outset that they didn't believe that their child was disabled or didn't believe that they have this disorder. But that may be because further down the line, they are worn down by constant sanctions, etc., and they've gone off and got some legal advice, and the legal advice has been your child's disabled and actually they're protected because they're disabled, and this is what you can do about it, which might prevent them from being permanently excluded from the school or might get them reinstated to the school. I mean, unfortunately, from a legal perspective, it's very difficult for me to tell you how you can persuade parents to be supportive of referrals, etc. I mean, I'm assuming that's what you mean. I'm assuming you don't mean parents who are unsupportive because they're not adequate parents and that's why the child's disruptive and you're not getting the support of the parents in relation to sanctions. I assume you mean you don't have the support of the parents in terms of, yes, yeah, thank you, in terms of referring. Unfortunately, it's not really a legal question that I can answer. You would just have to continue to try and work with the parents to explain the benefits of being assessed and the fact that if they are assessed, you can get recommendations which you can then implement, which could reduce the risk of sanctions being imposed and increase their access to education, etc. But obviously you've got much more experience of dealing with parents than I have from a legal perspective down a screen. It's just one of the situations that unfortunately you have to deal with. I mean, obviously, as I tried to explain, sanctioning, applying your behaviour policy to disruptive children who could be disabled. I mean, if they're not disabled, it isn't a problem because they don't have the protected characteristic of disability. They might have other protected characteristics, things like race, etc. We haven't really touched on that in this session, but obviously, just because the exclusion guidance points out that certain categories of children are more likely to be excluded doesn't mean that it's unlawful per se to exclude them, for instance, from school, as some parents seem to think. But we have focused almost entirely on disability in this session because that's what we come across day in, day out with schools struggling to deal with highly disruptive behaviour from pupils who are protected as disabled pupils. And it's all about making sure not only that you do everything that you can possibly do and that you ask for help from everywhere you can possibly ask from, but that you document all of this and that you document the impact of it. Everything you try, is it working? Thank you. Is it working? If it isn't working, what else can we try? And when you get to the point where actually you have put in place all the support you could have put in place, reasonably put in place, and it isn't working, then it will eventually come a point where you can lawfully permanently exclude a disruptive child. And it may well be that this is happening at the same time as you trying to liaise with the parents and the local authority, often when there's an EHCP, about whether or not the placement's appropriate. And obviously you've got to be careful not to, you have to be really careful not to be putting the pressure on the parents to move a child to a different school, because that could be considered to be almost like informal exclusion from school, unlawful off-rolling, etc. So it's a minefield that you have to navigate. But you know, often you have to go down the route of threatening permanent exclusion in these cases, just to preempt people recognising that the placement isn't suitable. You don't obviously want to find yourself in a situation where you have a disability discrimination claim, because like I say, even if your legal costs are covered, the emotional and burden, the stress that it causes for your staff over a very intensive 4-month or so period cannot be understated. You know, you'll have us on your back permanently for at least the first 5 or 6 weeks when you're meeting the first direction. You know, it's something that you don't want to get yourself in a position of doing. But if you do find yourself on the receiving end of a disability discrimination claim, at the very least, if you have met all of these duties and created an audit trail of your decisions and everything you've tried and what the impact was, and when you make decisions on sanctions, make sure you record that you considered your equality duties, you considered the fact that the pupil's disabled, you considered whether or not they were relevantly disabled, i.e. is this misbehaviour a manifestation of that disability, or linked in some other way indirectly because it's born out of the pupil trying to please people that he's easily influenced by, or you know, that sort of thing. Make a record of what you decided. No, I decided that there is no link between the disability and the misbehaviour that I'm dealing with. Therefore, there is no need for me to adjust the policies. This is my rationale for making that decision. If somebody comes along later and says you didn't meet your duties, your equality duties, you'll be able to say, yes, I did. And here's my contemporaneous notes that says what my decisions were and what my reasons for my decisions were. So I did meet my duties. I decided on this occasion that actually this was the right decision to make. There was no link between the disability and the behaviour. But it's always a question of, I hate to say ticking boxes, because that makes it sound like you can have a checklist, and something that we've been quite reluctant to produce is a checklist, because this isn't a tick box exercise. Equality is not a tick box exercise. Everything is very much case specific, unfortunately. And obviously those of you that have retainers, and most of you have retainers with us, please, just if you're dealing with a pupil that you believe just possibly might be disabled, if they have SEN and there's a possibility they might be disabled, before you make the decision, before you do the exclusion letter, if you're going to suspend or exclude, just pick up the phone and have a 20-minute sense check with us, and we'll ask the right questions and get you on the right track to what you need to produce in terms of evidence and what you should put in your letter. And that will then start you off on the right process with these decisions.